Hello and welcome, everyone. Today, we are diving deep into a really critical tax issue that's creating a huge buzz for businesses all across India. We're talking about something fundamental: Provident Fund and ESI contributions. You see, there's been this long-running dispute over late payments that has finally, and I mean finally, reached the Supreme Court. And trust me, the verdict could shake up balance sheets by crores.
So here's the big question, right? It sounds simple enough. If a business deposits its employees' PF or ESI money just a little bit late, can it still claim that amount as a tax-deductible expense? But wow, the answer is anything but simple. This is the multi-crore question that affects pretty much every company out there, and it's the one the Supreme Court is now getting ready to answer for good.
So to make sense of all this, we've broken it down into 6 easy parts. We're going to cover the Supreme Court's big move, really get to the heart of the dispute, unpack what the law actually says, see how different high courts have been totally divided, and most importantly, we'll talk about what this all means for you.
Okay, let's jump right in, starting with the headline news.
So here's the big development. On January 27, 2026, in a case involving Woodland Private Limited, the Supreme Court of India officially issued a notice to hear this whole matter. So why now? Well, because for years, different high courts all over the country have been giving completely opposite judgments, which has created, just a ton of confusion. So the Supreme Court has finally stepped in to bring some clarity.
Now, let's really get to the root of this. What is this fight really all about?
Okay, so here's how it works. Every business, as you know, deducts PF and ESI from employees' salaries, and they're supposed to deposit that money with the government. The key question is this: if there's any delay, even a small one, in making that deposit, can the business still count it as an expense to lower its taxable income? This is not a small thing. We're talking about a question that's literally worth crores in tax money.
This entire massive dispute really just boils down to a clash between 2 different deadlines. That's it. On one hand, you have the super strict due dates set by the PESI laws themselves, something like the 15th of the following month. And on the other, you have the much later due date for filing your annual income tax return. The whole argument is about which of these 2 dates is the one that really matters for claiming your deduction.
So to really get why there's so much confusion, let's take a look at what the different sections of the Income Tax Act actually say about this.
First up is Section 224X. Now, this law has a really fascinating rule. It says that when an employer deducts money from an employee's salary for PF, that money is legally treated as the employer's income. It's basically seen as money held in trust, and amanat. And this is a really important way to make sure that these funds, which belong to the employee, are protected and handled the right way.
Okay, next up we've got Section 36(1)(va), and this one sets a very specific condition. A shart. It says that an employer can only claim a tax deduction on that amanat money if it's deposited by the due date that's mentioned in the specific PF or ESI law. The language here is pretty clear. If you want the deduction, you've got to meet that strict original deadline.
But, and here's the twist that created this whole debate, Section 43B. This section acts as a sort of grace period for a lot of other business expenses. It lets you claim a deduction as long as you make the payment before you file your income tax return. So the huge argument is whether this grace period also applies to the employee's contribution, or if that other section, 36(1)(va), just overrides it completely.
And this legal gray area is exactly why high courts all over the country have been split right down the middle, into 2 opposing camps.
So on one side, you have Team Revenue, which is backed by the high courts of places like Gujarat, Madras, and Kerala. Their argument is that employee contributions are special trust, and amanat, so that strict PF Act due date has to be followed, period. They say the grace period from Section 43B just doesn't apply here. But then, on the other side, you've got Team Taxpayers, supported by the high courts of Delhi, Calcutta, and Karnataka. They believe Section 43B should absolutely apply, letting businesses get the deduction if they pay up any time before filing the ITR.
So, with the country's courts so clearly divided, what exactly is the Supreme Court doing about it now? It's a pretty decisive move. The Supreme Court basically looked at this whole situation and realized that having different rules for the same tax law in different states just creates massive uncertainty for everyone. So that's why they've taken up the case, to set one single binding rule for the entire country.
As a matter of fact, the court's own order said, and I'm quoting here, "In view of the conflicting opinion, we would like to look into this issue." Just that one line, straight from the court,
really shows you how serious this problem is and makes it clear they intend to settle this debate once and for all.
Now, this is a really important point to remember. The Supreme Court has only agreed to hear the case. They have not passed a final judgment yet. The final decision is still a ways off, and until then, well, the legal uncertainty technically continues.
So while we're all waiting for that final decision, what should you and your business be doing right now? Let's quickly go over 3 essential takeaways. First, the absolute safest bet is the zero-risk approach. Just always deposit employee PF and ESI contributions before that original statutory due date. No gray area, no risk. Second, you have to understand the litigation risk. If you are banking on that later ITR due date, just be ready for a challenge from the Income Tax Department. The final outcome is going to depend completely on the Supreme Court. And third, stay updated. Keep a close eye on this case because whatever the Supreme Court decides will become the law of the land for everybody.
And that really just leaves us with the final big question. Which side is going to win? Should the special in-trust nature of employee funds mean we need a strict deadline, siding with team revenue? Or should businesses be given the flexibility of the ITR due date, which is what team taxpayer is arguing for? It's definitely something to think about as we all watch this landmark case unfold.